Okay, everybody. My name is Stephanie Harrison. I'm one of the heads of chambers at Garden Court, and we are very pleased to welcome you to this seminar, which is part of a seminar that was running last year by our criminal team in looking and focusing upon racial stereotyping and discrimination within criminal justice system. It seemed to us at the end of that seminar that linking the practices in respect of criminal justice with what was happening in the immigration system was critically important. And for that reason, we have put together this webinar in order to look at how racial stereotyping and gang mythology feeds into deportation, in particular looking at the policy which many of you may know about called Operation Nexus, which is a wide-ranging government policy covering both crime and immigration, whose tentacles go much further than that, but focus on crime and immigration. And we're lucky to have a combination of speakers, both immigration practitioners, academics, advocacy coordinators, and caseworkers, and a person whose family is directly affected by these policies to speak to you today. So before I introduce them, I've got to just give you the basic information about how we're going to conduct the webinar, which I know you'll be familiar with from having now all of us got very used to this form of communication. So obviously everybody is on mute. We have a chat function where you can put in any comments or questions. We hope to be able to take questions at the end. Unless you've got some very burning issue of clarification, I'll leave those until the end so that we can deal with them all in one go. You will have resources that are produced today circulated to you before, if not now, then after the webinar. The webinar is being recorded and it could be used for wider distribution, including being placed on YouTube. So I hope that everybody is happy to consent to that. If you do have any technical difficulties, whilst we can't guarantee that we can assist directly, if you put them in the chat, then Amy, who is part of our marketing team at Garden Court, and also now a technical expert, as everybody has had to be following the lockdown experiences, she may be able to assist you. So those basic details I hope are familiar, and I think they are repeated in the chat in any event. So just in terms of how we're going to approach today, I'm going to give a very brief introduction and then we're going to follow on with the speakers. Our purpose in pursuing the seminar was to make the very important connection, just as the government authorities have done, between crime, criminalization of young Black people, particularly who are alleged to be involved in gang activities, to see how those interrelationships have been taking place, and to try to make better connections between immigration and criminal practitioners. It may be, if you're a criminal practitioner, that the point at which this issue intersects is going to be the police interview, because we know from Operation Nexus that immigration officers have been embedded in police stations when questioning is taking place and the case has been flagged as a Nexus case. It may be that it only becomes apparent at the point at which there's a sentencing issue, and certainly at the point in which someone's sentence may come to an end, or if they're acquitted, because they may face immigration detention. At each of those points, a person's immigration status may be relevant to how they are dealt with within the criminal justice system, and certainly at the conclusion of it, it will be critically important. That's because, as you may know, the government has been operating since 2007 a policy of automatic deportation of any person who is convicted of a criminal offence which attracts a criminal penalty of imprisonment of over 12 months. So that's a very large potential group of people who will face automatic deportation following conviction. But even wider than that, any person who is involved, even without a conviction, in activities that are related to gang activity and have been identified and intelligence collected can be at risk of deportation on public interest grounds and will face grave difficulty in resisting deportation, even if that person has been born in the United Kingdom or has been in the United Kingdom from a very young age. The protections for young people facing expulsion to countries where they have little, if any, direct experience or knowledge has increasingly been eroded. And the government have made it a priority by introducing first rules and then statutory provisions to strike the balance between the rights of the individual to family and private life and the public interest in deportation, those who've been involved in criminal activities, very much in favour of the state. And so young people who definitely 5, certainly 10 years ago, who would never have been at risk of deportation now do regularly face being subject to prolonged detention with the aim of deporting them and separating them from all extended and close family members in the UK. And it isn't just those who don't have an immigration status. There's many children who've grown up in the country who've never had their status regularised, but even those who do have leave to remain, including those with indefinite leave to remain, so anything less than citizenship, are at risk of deportation. And so we hope to be able to bring together expertise from both the criminal justice system and from the immigration context to see how we can best develop strategies that do aim to address some of the very serious abuses in some respect that take place by the use of and misuse of intelligence information obtained through Operation Nexus, and to call out and to identify where it does occur, the fact that a lot of this so-called intelligence is based on racial profiling and racial stereotyping, and does result in very grave adverse impacts, not just on the particular individual who's faced with deportation, but as we're going to hear from Joan and Maria, on their close family members and their extended family. Often these are high integrated young people who've spent most of their lives in the United Kingdom with extensive networks of family and friends. And so we hope that, one, it will give you, whilst it will help to see how the connections can be made, we can also look to find practical ways in which we can assist each other in providing as effective representation we can for this particularly marginalized and often demonized groupings of young people. So what I'm going to do first is ask Greg O'Keeley to speak. He's an immigration, public law and human rights barrister. He has a lot of expertise in representing those who face deportation in this context. And he's going to first give you an outline of the law and the problems that arise, and also present what we hope are some practical solutions for you to think about and to contribute to in how we might address these issues. So Greg, if I could ask you to speak first.
Thank you very much, Stephanie. I'm just going to share my screen first of all. And hopefully that's worked. Thanks everyone who has come along to hear about this important issue, and I suppose to those of you who just see how my hair is got. The point of what I want to do now is just to give a kind of overview of Operation Nexus. And this is an issue that's really close to my heart. So I've been doing immigration law now for, I suppose, 13 odd years. But certainly at the beginning of the time I was doing that, and certainly for about 5 years, I used to do criminal defense work as a criminal defense barrister and did a lot of trials. And it was really striking when I first started doing these Operation Nexus cases. It was really striking to me that what they appear to be more than anything else, is a criminal trial that's run without the defense there, where people are obliged to try and defend themselves without most of the tools that you have as a criminal lawyer. So what I want to do is try and give you an overview of the Nexus system, how it works in the deportation context, look at some of the key authorities and some of the key legal principles, and then analyze and develop some of the problems that arise and suggest ways in which we as lawyers can work together to try and solve those problems. So this is going to be very much about the mechanics. I think Dr. Palmer is going to talk a little bit about some of the kind of underlying issues and the forces that give rise to the Operation Nexus system. So first of all, there are actually two strands to Operation Nexus, and the first strand is the means by which immigration officers are deployed to police custody suites, and that's something that Stephanie's already mentioned, to examine all foreign nationals who are arrested and identify those who are illegal entrants suitable for detention, and those who will be progressed for removal. And you have to remember that the Operation Nexus system comes in the context of the Charles Clarke and John Reid eras, when the Home Office system for deportation was being said to be not fit for purpose. And everything you really see with Operation Nexus comes out of the kind of heavy press attack on the government from the right for the failures to remove people or deport people who committed crimes. So that's the first part of the Operation Nexus system. The second part is the part I mainly want to talk about this evening, which is Nexus high harm cases. And police forces refer high harm cases to their team where an individual is deemed to be a threat to the public. The team assess every referral and establish whether the known offending justifies referral for immigration enforcement action. Well, you might think so far, fair enough. The action can include administrative removal, conviction-led deportation, and intelligence-led deportation, which is where I think the main problem lies. So what is a Nexus high harm used for? First of all, deportation following criminal conviction under Section 3(6) of the Immigration Act and Section 32 of the UK Borders Act. So Nexus cases don't generally have as much purchase in these cases, because these are cases where deportation is happening anyway, either because of a court recommendation or because of the automatic deportation provisions that Steph's already talked about, although they may also be Nexus cases. Secondly, deportation on the basis that a person's presence is not conducive to the public good. And we'll talk about a bit more about that in a moment. And thirdly, administrative removal. Now, I know that a lot of the people here are not immigration specialists, and it's important to distinguish between administrative removal and deportation. If somebody has to leave the country, they often say that they're being deported if it's forcible. But actually, there's a distinction between administrative removal and deportation. Deportation follows criminal offending or a conclusion that a person's presence is not conducive to the public good, whereas administrative removal just follows you not having permission to be in the country. So, for example, if your leave is expired or your leave is curtailed. What does high harm mean? Right. For purposes of Operation Nexus, foreign national offenders are considered as high harm where their conduct incurs significant adverse impact, whether physical, emotional, or financial, upon individuals or the wider community. But what does that mean? The team also leads on intelligence-led deportation in cases where disclosable police material is utilized to justify deportation action where there are no convictions. So intelligence-led deportation means where the police think that you did it, but you weren't convicted, or no charges were brought. So generally speaking, intelligence-led isn't referring to MI5 or MI6. All of that stuff in terms of risk posed for terror offences is dealt with in an entirely different context in the SIAC proceedings. Intelligence-led here means police intelligence. So who gets referred? So all foreign national offenders who receive a custodial sentence are referred for deportation. So they don't go into Operation Nexus as a gateway. They just get referred for deportation in the ordinary way. But separately, foreign nationals may be referred to the Home Office Nexus team where they are lawfully present, so here with leave to remain, but the subject of active police interest, and there's evidence that their conduct meets the definition of high harm due to a current and ongoing threat to the public or persistent criminal activity. So current and ongoing threat to the public means on the basis of police material, which is on the basis of police evidence, which means effectively that the police believe that you constitute a harm to the public. if you're somebody who's not lawfully present and subject to access active police interest, Operation Nexus will mean that they just make it a priority to remove you. So in principle, a person in that position will be removed anyway. But if you end up in the Operation Nexus net, then you'll be somebody that they prioritize removal for. So what does that mean in practice? Who gets referred? So in practice, what that means in general is people that the police have not been able to secure convictions for. So the classic example is your gang member or your alleged gang member. So somebody who the police believes involved in criminal activity. They may have been the subject of a number of criminal charges that haven't gone anywhere. They may not have been the subject of any criminal charges who've got anywhere, but nevertheless, they end up in the Operation Nexus net. So, I mean, one example I saw was a young Jamaican boy whose brother had been the leader of a criminal gang and had been deported. And he was alleged to have been involved in the gang, and most of the evidence of that was the fact that he had been in the area when his brother had been in trouble. And we'll talk a bit about the evidence shortly. So what happens in an Operation Nexus deportation case? Well, first of all, the real difference that you notice in these cases is the police take a really active role in deportation. So in an ordinary deportation case, what you'll have is a police national computer printout of the criminal offence, and any other offending. You'll have the sentencing remarks from the judge, typically in the Crown Court, because usually you'll have a sentence of 12 months or more if it's automatic deportation. You will generally also have a pre-sentence report setting out what risk the individual poses, all these things that the tribunal needs to have. Secretary of State needs to have, first of all, to decide whether deportation is proportionate. Spoiler alert, the Secretary of State does think it's proportionate. And the information that the tribunal needs to have to decide whether or not an appeal should be allowed. So evidence from the court, evidence of the offences in terms of what the PNC is, and any pre-sentencing reports to determine the risk that a person poses. But in an Operation Nexus case, what you get is a huge bundle of evidence. You know, you're often talking a couple of massive lever arch files or more, and that forms the basis of the decision to deport. And at the actual tribunal hearing, instead of there being an immigration lawyer on behalf of the individual, or no lawyer if they've got no legal aid, and a Home Office presenting officer, you will also have a witness who will be a police officer who will turn up in uniform to give direct evidence as to the risk posed by that individual as to their criminality. So, how is the evidence in the tribunal different from evidence in the criminal court? Well, I think it would be quite shocking, actually, for most criminal lawyers to actually spend a day in the first tier tribunal watching what happens in a deportation case. It is basically bandit country. There are no rules of evidence to speak of in the first tier tribunal. The tribunal procedure rules say that the tribunal may admit evidence whether or not the evidence will be admissible in a civil trial in the UK. That's a civil trial in the UK. So never mind what will be admissible in a criminal trial. So you'll have there's nothing equivalent to the kind of PACE protections that you get that allow prejudicial material to be removed. Nothing equivalent to the provisions that would allow hearsay evidence to be kept out. Evidence will include police intelligence. The standard of proof is the balance of probabilities, and previous acquittal does not prevent the same case being made again. So you can literally be, as we'll see, be acquitted of the offence of, say, murder, and then the Home Office can seek to deport you based on the allegation that you did in fact commit the murder that you were acquitted of, based on hearsay evidence. And secret sources can be relied upon as well. So the first kind of big case in this was V against Asylum and Immigration Tribunal from 2009. It was Mr. Justice Higginbottom, as he then was. And in that case, the appellant was alleged to be a gang member. And the Home Office sought to deport him on conducive grounds, so on the basis that his presence in the country was not conducive to the public good. And they relied on 3 spent convictions, so really minor stuff from when he was young, an allegation of involvement in a murder, and this is exactly what happened. He'd been acquitted of the murder in circumstances where the judge looked at the facts and kicked it out at halftime. Mr. Justice Morris, I think it was, kicked the case out at halftime following an application by the defence. He considered that the evidence was much more tenuous against him than against another individual who was suspected. There was an allegation that he'd been seen with a gun on the day of the alleged murder. and there was criminal intelligence saying he associated with gangs, and there was 800 pages of CRIS report data collected from unnamed secondhand hearsay sources. And the expression unnamed secondhand hearsay sources is not one that I have used for exaggeration or effect. It's the one that Mr. Justice Higginbottom used in the judgment when he's saying that was all totally fine. He held that the appellant's case in that case failed. That was actually a judicial review where the appellant was judicially reviewing the decision to bring this case against him at all, on the basis that he'd already been acquitted of the same murder. And he said, Mr. Justice Higginbottom said it wasn't an abusive process and such evidence was admissible, because while it inevitably loses considerable weight by being anonymous and partially hearsay, and you can't directly challenge any of the witnesses, I can't say that the evidence must inevitably be given no weight by the tribunal. Remember, we're in balance of probabilities territory, or that to admit the evidence at all will deny the claimant a fair hearing. Well, I mean, I don't think there's any real doubt that it would deny him a fair trial in a criminal court, but as we'll see, we're in bandit country. It's not the same in the tribunal. The second big case on this was a decision in Ba. The claimant in that case, appellant was that case was alleged to be part of the anti-Sharman gang. I include that because I just like saying anti-Sharman gang. The first tier tribunal was relying on CRIS reports, criminal and other police intelligence, the sources for which were not disclosed. The tribunal held in that case that any specific allegations made had to be proved to the civil standard. So you couldn't just say, this is a guy who's involved in robberies. You had to say, if you're relying on any robberies, they had to be proved individually to the civil standard. And the tribunal drew a distinction between whether hearsay and anonymous evidence could be admissible versus the weight that it could be afforded applying V. The tribunal held the civil standard is flexible according to the nature of the allegations made, and a tribunal judge should be astute to ensure that proof of a proposition is not degraded into speculation of the possibility of its accuracy. Now that's all well and good, but if all of this information is admissible and is already before the tribunal, expecting the tribunal to be able to make a decision as to whether any individual thing happened while putting out of its mind all of the other information that is effectively just asserting that there's no smoke without fire is, I think, totally unrealistic. Farquharson was the other big one that followed shortly afterwards. Most of these cases are 2012, 2013. And the Home Office sought to deport that appellant on the basis that he'd in fact committed a series of offences, none of which had resulted in convictions. They were a series of alleged rapes, really quite unpleasant facts in this one. The tribunal held that he had in fact committed most of these offences and dismissed his appeal. It also held that a criminal charge that has not resulted in a conviction isn't a criminal record, but the acts that led to the charge may be established as conduct. So the Home Office couldn't say, we're convicting you because you have a rape conviction when you're acquitted of rape, but they could say, we're convicting you because you have committed, because you've had sex with somebody when they didn't consent to it, which is bad conduct, despite the fact that you were acquitted by the same of the same charge by a jury, for example. If your respondent relied on police CRIS reports, they should be produced rather than a bare witness statement referring to them. As you might guess, the reason the tribunal said that was because the tribunal had convicted the individual, or had dismissed his appeal, relying on a witness statement from a police officer, not even the reports themselves, but just saying that there were such reports, and it had all been given to them too late. Importantly, they also said that where an appellant is in detention and faces an allegation of serious conduct, it's in the interest of justice, legal aid. That's a really big issue. Crucially, if the material renders itself capable of more than one interpretation, we should only draw an interpretation adverse to the appellant if, on the balance of probabilities, there's no other reasonable explanation on the material before us. Now, that's a very helpful expression to use in these cases, although I'm not entirely sure it's completely coherent. It seems to be a kind of mishmash of the balance of probabilities and a Wednesbury threshold. So what actually goes in? If you are trying to respond to one of these criminal allegations in the tribunal, you'll be facing police intelligence, and that will include criminal reports, anything from the PNC, anything else that the police know or suspect. Statements, including police statements saying that your client is involved in gangs on the basis of their knowledge, on the basis of them being seen near criminal activity. It's frequently the case that you'll have witness statements or CRIS reports saying that person X was seen in the vicinity after we know that a robbery took place earlier that day or earlier that afternoon. Being associates of known criminals, including, for example, your brother or your best friend or somebody who lives on the same street as you. And Dr. Palmer will talk about this a bit more later, I think. But I mean, there are obvious problems with people living in areas where there's quite a lot of crime, and saying that they are seen in areas where a crime has taken place or associating with people who've been involved in crime. Chris reports, including or allegations, resulted in acquittals or even no charge, CAD. Victim impact statements in the V case, the victim impact statement went before the tribunal, even though the person had been acquitted of the murder alleged. I think you'd really struggle to get that in a PACE context. Any allegations substantiated or not, including just police suspicion, having been stopped and searched, which is one that infuriates me. And I think, everybody will be aware of the racial disparity in who gets stopped and searched. And the fact that the person has been stopped and searched by the police is a thing that will be relied on by the Home Office as saying that there's somebody who may have been involved in crime. Having been stabbed or a victim of crime or witnessed a crime, and basically more or less whatever you're having yourself. So what actually happens in practice? So the Home Office uses this huge bundle I spoke about earlier of evidence with a short MG11 witness statement explaining the contents. An officer then attends the tribunal, dressed up in uniform, looking very impressive. It's not like being in the Mags or being in the Crown Court, where the judges are used to seeing policemen all the time. Frankly, my experience is that first-tier tribunal judges often are quite impressed by seeing a policeman in uniform who walks in and says that the person that they're considering deportation for is actually quite dangerous. Often the officer won't really be the one who's prepared this document and may not be familiar with its contents, despite the fact that they come effectively to give evidence about it. The Home Office will generally say that all of the bad things that this bundle suggests that your client has done are true, or at least any ones for which there is any real evidence at all. There'll be no direct evidence from or opportunity to cross-examine any of the people who were making the allegations, the factual claims in the documents, none at all. So none of the people saying that your client was involved in any of the things in the documents will be there for you to ask them any questions. It may not even be clear who's making these claims at all. And then the tribunal will decide whether these things are true and the balance of probability. So to give an example of one case I saw, there was a young man who was accused of a serious sexual assault. He was tried by a jury. He was acquitted of that sexual assault. He had indefinite leave to remain. His case was referred to Nexus. It was his only offence. The Nexus team referred him for deportation, and then he ended up in the tribunal in Nottingham. And essentially, they just reran the rape trial without the defence there. And I'm not exaggerating, he had no representation. A police officer turned up with the allegation and the details of it in a file, a short witness statement addressing it. The guy in question didn't ask the policeman any questions in cross-examination because he didn't know he could, didn't even know he should. And the first tribunal judge then just found that he had done it, and he was sent for deportation on that basis. So that is the kind of thing that happens. How does all this fit with Article 6 and the right to fair trial? That's a good question, and the answer is it doesn't have to. There's a case called Moui against France, which establishes that Article 6 doesn't apply to immigration or removal proceedings. You don't get Article 6 if you're an immigrant, effectively. If it's an immigration case, you don't get Article 6. And that was on the basis that the exclusion order, although it had major repercussions on their private and family life and prospects for employment, that didn't mean that that was within the scope of determining their civil rights as protected by Article 6.1 of the Convention, which I have to say, the first time I read that case, I couldn't believe it. It may be that there's a bit of room for revisiting Moia recently. There have been a bunch of dissenting decisions suggesting that it's right for revisiting. And I think this is a kind of case where it really could be revisited because it's really closer to the determination of a criminal allegation than it is to your civil rights. And certainly, as Judge Pinto de Albuquerque said, these decisions will necessarily have major repercussions on the alien's private and professional and social life. And secondly, they're not discretionary at all. And when the member states are making those decisions, they have to comply with international obligations. So I think there is scope for revisiting Moia, but for the moment, we don't have Article 6. So what can we do? Well, as an immigration lawyer who has had to deal with these cases, I think my view is that cooperation is absolutely vital between the criminal and the immigration spheres. Information. So if the prosecution failed, the criminal lawyers will know why, but it may not be clear at all from the information. Now, I'm not suggesting the police would conceal it from you, but if, for example, you did there was a criminal trial where somebody had alleged a robbery, and that individual had been referred to Nexus, and say, for example, they've complained completely falls apart in cross-examination and admits they made it up. That's not the kind of information that would necessarily make it into the Nexus bundle. So the criminal lawyers will know that. They will know why a case failed in a way the immigration lawyers won't be able to piece together from the information that they have. It's really important that criminal files are shared as quickly as possible. It's really easy for us to say that. We need them. And I know that criminal lawyers are under massive pressure and they don't have the funding for this kind of stuff. And often these documents go straight into storage, but it's absolutely vital that we have the information that we need to combat these kinds of allegations. Documents such as counsel's attendance notes as well can be really, really essential. Continuity of care. This is again about cooperation. If a client's detained following conviction or acquittal, it's essential to ensure that they have access to immigration lawyers, because what's coming down the track could be really serious and could be far more serious in consequence than what they were actually facing in the criminal courts to start with. So I hope that's a helpful overview. I hope I haven't gone on too long. And thank you very much for your attention.
Thank you very much, Greg. I was going to just confirm what Greg said about the kinds of material you get. I can't look at it, but I'm just going to show you if I can. A case that was heard last week had this amount of material of Nexus information that was relied upon against that particular young man. It goes back to 2002 and concerned and the only conviction he had was in 2011. So I think there was a question that we were asked about rehabilitation of offenders, act and spent convictions. Greg explained that the fact that a conviction is spent is treated as irrelevant. There is a specific exemption from the Rehabilitation of Offenders Act when it's concerned with immigration matters. So none of those presumptions, none of those important recognitions that a person has served their sentence and has rehabilitated apply directly in the context of immigration appeals. And you are literally facing what can be over, well, in that case, it goes back to 2002. So well over a decade of material and information that's been collected on those people. And you are often facing a situation where it is about very old conduct or very old offences, because what the government did was when they introduced Operation Nexus, they didn't just deal with it going forward. They searched their files for other people and brought deportation proceedings against them. So one example of a case that I had was a person who was 25 at the time, but had been convicted when he was 15 of a sexual offence involving a child, another child who was 13. And essentially, as Greg said, is that you are having to rerun and re-argue past allegations that have either been rejected or have never gone to trial, or where acquittals have arisen. So the challenge for us is enormous. And some of the observations that Greg made about practically how we can coordinate, and hopefully at an early stage, I hope we can take forward and think about how we can do that. We are going to move on now to our second panelist, and we're incredibly fortunate to have Dr. Alpa Palmer, who is the Associate Director of Border Criminologies at the University of Oxford. I don't know if any of you are familiar, some of you will be, but the Borders and Criminology department at the University of Oxford does some of the most important research in the country in monitoring and identifying, in particular, the interrelationship between criminal law and immigration law, and from a racial perspective. Dr. Palmer has been involved in research to understand how race disproportionately impacts on Black people and others within the criminal justice system. She has been looking at the policing response to global mobility and its racialized consequences. And she has, within that work, had a particular focus on Operation Nexus. It might be, I hope you don't mind, Dr. Palmer, we had one question in the chat that was asking about the use of the term gang and how that in itself is a racialized term, and whether or not there is any basis for it. Has it had any analysis in the academic context, and are there means of challenging the use of words and terms like that do become associated with particular racial groups? I hope you don't mind. I know you're going to speak about other things, but if you could bear that in mind, I'd be very grateful. Thanks very much.
Thank you, and thank you to Garden Court for this generous invitation to be part of this important panel. So absolutely, thank you very much, Stephanie. I shall come to the question about gangs perhaps at the end of what I'm going to say. So I've been looking at Operation Nexus, and I've been looking at it by researching police custody. So I've been doing ethnographic work within police custody suites to really see how this embedding of immigration officers within that space has worked or not worked. And as part of that, I've conducted over 250 hours of observation within these custody suites. I've also been following immigration enforcement operations. And most recently, I've been hearing some of the immigration tribunals that Greg talked about a moment ago. I've also been trying to look at some of the cases and looking at sentencing remarks, interviews with police officers, but also custody detention officers who are often dealing with some of the suspects that are brought in. And I've also been talking to high harm team officers, which Greg also mentioned. And lastly, I've looked at the criminal record. I've talked to people at the Criminal Records Office too. So some of the issues that Stephanie mentioned about the previous convictions or suspected offences and what gets recorded at the Records Office, I've been looking at too. So I suppose my interest has really been around looking at the changing nature of policing, given this merger between immigration and everyday policing, and essentially how police intelligence is used in immigration tribunal hearings, and also really what counts as evidence in these cases. I'm just going to briefly talk about 4 issues that have arisen from my research, and there's some overlap with what Greg has already said, and also so I'll talk to those 4 issues very briefly. So firstly, I'm going to talk about the pliability of police intelligence in Nexus cases, and also the reliance on the gang myth. Secondly, I'm going to talk about the dangerous and racialized consequences of this enmeshment between civil and criminal proceedings, which these immigration cases based on Nexus are actually creating. Thirdly, I'm going to talk about the impact on the everyday life of minority ethnic groups. And fourthly, I'm going to briefly touch upon the issue of how Nexus really legitimates the application of race as a proxy for nationality by the police. So the pliability issue then, and the reliance on the gang myth. So police intelligence, from what I saw, was often gathered purposefully once a decision was made to target an individual, rather than the intelligence actually driving the suspicion, as is supposed to be the case. There was a reliance on the racialized tropes of gang membership as assigned to Black and Asian men, and the Met Police's gangs matrix, which is patterned by race, which we all know, was often consulted to see if a suspect was on there. But this also worked the other way around. So where if a suspect was brought in and their leave to remain was uncertain, they could be added to the matrix if they were friends with a suspected gang member, for example, and so on. So it really highlighted the arbitrary nature of the gangs matrix, which has been discussed by other people, and including the fact that 72% of those on the matrix and flagged for gang violence are Black. Being on the matrix, I saw, was often used as evidence of gang membership and criminality, seen as a source of serious harm in immigration hearings. And the process as I've suggested is really circular. There's often no clear factual basis upon which someone is for certain a gang member or not. Partner agencies, including social services, job centres and so on, can apply for someone to be added to the matrix. Ironically, the news today reported the removal of 1,000 young Black men being from the matrix database. But I suppose the fact that names can be added and removed so easily further underscores its vague nature and the fact that it's a fundamentally discriminatory tool. In my research with the police, I saw that criminal intelligence detectives would often scour YouTube videos of grime artists to identify gang names or other insignia to affix the gang label to individuals. Often they didn't know what they were looking for, but the point is that any subcultures that people engaged with or suspects accessed immediately put them under suspicion of being a gang member. And there's some evidence that Operation Nexus was actually developed as an immigration response to the policing problem of gangs in the first place. And this is not unusual. So we often are seeing immigration control as being shaped as a solution to criminality, as much of the academic literature on crimmigration illustrates. So to flesh out some of the points that Greg made, I found examples in my research where an individual may have been brought into police custody as a suspect, then released with no further action. However, if the suspect had an uncertain immigration status, this was seen as a chink in their file and noted and seized upon, and often the individual and his or her friends were subjected to enhanced surveillance and further investigation, both physically and online. The other areas of pliability within Operation Nexus seems to be around the definitions of a persistent offender. So as people have already touched upon, sometimes reports or evidence of offending or suspected offending, which has not actually resulted in a conviction, is brought forward in cases. In one of the cases I heard, the appellant, a 20-year-old, had 3 convictions and 2 of them were in 2013 and therefore spent. And I heard this case, I think it was 2018. And also they were for petty offences. In a couple of the examples, police provided evidence of supposed criminality. The appellant was actually the victim of a crime rather than the offender. So as Greg said, all evidence counts. I mean, this is a real example of that. Similarly, as Stephanie pointed out, in another case, the appellant was a minor when he convicted the offences, yet was still presented by the police as evidence of his persistent offending behaviour. And the key is that it's supposed to be current offending behaviour. So the fact that previous evidence brought or previous offences are brought forward is questionable. So the other concept which seems to be really quite pliable is the high harm concept too. And I found that it was often very weak and reliant on kernels of information of ancient and spent convictions. I saw minor offences including cannabis possession, driving without insurance, suspicion of burglary, all of which were deemed enough for the police to suggest that accumulation of these offences could amount to high harm or that the person was a threat to the community. So the second issue that I've really seen is the dangers of this enmeshment of civil and criminal law processes. Immigration judges seemed accustomed to a civil arena, and when presented by intelligence from police officers, including witness statements, incidents from internal police systems, they seemed to really buy into that and took it as evidence. Gave it significant weight. So information on Chris, for example, on Chris reports is often very subjective and unreliable, yet nevertheless it was taken as a given. Stop and search activity too, as Greg pointed out. The other evidence that I saw given by police officers was that it was potential criminality rather than actual criminality that was presented as someone being at risk of committing further crime. Sometimes a person's previous convictions, rather than them being assessed as presenting an actual risk, was given as evidence as the person being detrimental to the public good, for example. Also, many examples of hearsay evidence that I've seen. So the Barr case, where it was his alleged gang membership was the primary decision on which to deport, yet information about his gang membership was provided by the police officers via video call, and the officers wouldn't disclose their sources, saying that they were anonymous. And we know that anonymous sources can't be summoned as witnesses or cross-examined in immigration tribunals like in criminal court procedures. The third theme that I saw was when I interviewed people who'd been subjected to Operation Nexus procedures, and I think Joan will also shed light on this some more. But I like to refer to this as a kind of creation of a hidden curriculum. Now, what I mean by this is that people change their behaviour in response to the fact that the police might build a case against them and make them vulnerable to deportation or removal. So people adapted their routes home, limited the times that they would go out, who they would associate with, they blocked their social media accounts and so on. And so this hidden curriculum, or a curriculum of knowledge, is this suggestion that academics Justice and Mears talked about, and they describe how the criminal justice system educates citizens to develop a negative relationship with the state. And mirroring this in my research, I spoke with people that learned that they must never be out and about without their Home Office papers. One woman I spoke with, her name was Adele, she was a victim of a robbery, but she felt unable to report it to the police for fear of being referred to immigration. So the police were no longer perceived as a port of call or a source of protection for her. And thinking through the implications of this, you know, if we think about women suffering domestic violence who feel unable to contact the police, for example. Other participants I talked about this erosion of sense of belonging they felt after having been subject to Nexus proceedings, this idea of feeling free but not free, and also reflecting what Daniel Kunstrom's talked about as people who are eternal guests in the polity. So people whose continued residence in the state is contingent on their good behaviour, regardless of the length of their stay in the UK or their degree of social integration. Fourthly, I think that what's happened and what Nexus really quite clearly shows is with it creeping beyond its stated aim of removing the most dangerous individuals, I found that the policy really elided nationality and race in police practice. So although the police are well aware of the dangers of explicit racial profiling, Nexus legitimised a focus on visible racial minorities under the guise of performing nationality checks. So in practice, this meant that white suspects were rarely checked for their immigration status, whereas racial minorities, even those with a strong English accent, would very often be checked. And immigration checks were sometimes used to encourage compliance from suspects or to enter a guilty plea, or simply to underline that the person was under multiple strands of suspicion. So, I mean, they're some of the themes that I really saw in the research. And I suppose I'd just like to conclude by thinking through about the nature of policing and race and what Operation Nexus actually illustrates to us. I mean, despite the challenges that have been brought against Nexus and the role of the police in questioning someone about their citizenship status, it was held that the police were able to ask someone lawfully about their immigration status. And this was a Court of Appeal case brought by the Air Centre in 2018. And I think it's important to remember that the police have always been involved in immigration. However, what we see with Nexus is its agility in latching on to ordinary policing practices. So it expands the policing toolkit in an amorphous bid to make the border more secure and to remove unwanted foreigners. And I suppose the Immigration Act in 2016 really formalised this blurring between police and immigration. So the police were given powers to perform more immigration checks, and immigration officers, for example, no longer were required to be trained criminal investigators to seize evidence. And lastly, so as criminal and immigration enforcement systems grow increasingly codependent, and when preemptive decisions rather than established facts seem to guide the outcome of who's granted the right to stay and who's detained and deported, I suppose we're really compelled to rethink whether investing the police with further mechanisms by which to discriminate and racialise groups is a justifiable means to an end. I'll stop there and I'll come back to the question, Stephanie, at the end, if that's okay.
Sure. Yes, of course, that makes sense. So obviously we've had the benefit of an analysis that is able, from Dr. Palmer, that is able to look at the whole spectrum of how this is operating at a generic or systemic level, which is obviously vital, and it's very difficult to get that kind of information. And it's key that we do have access to it and to see how that then can feed into what we can do by way of legal challenge to the practice. We are also going to hear from Joan Martin, who is one of the members of a recently formed campaign called Families for Justice. And Joan's experience arises out of the government's recent intensification of charter deportations of people, in particular to Jamaica. And obviously, this is very high profile. It builds upon the ideology and the demonizing that has occurred as a matter of general policy between migrants and criminal activity. Making that nexus is a key part of government ideology and publicity, backed up by a lot of what you hear in the media. And so we're very fortunate and very grateful for Joan to be willing to come along and share her direct experience of what that has meant for her and her son, who was subject to a proposed deportation in the most recent Jamaica charter flight before Christmas. And she's going to give us some of an insight into what happened to her son and her experience directly of how this policy impacted on her family, and also give us some insight into how, once you establish this kind of policy, first of all focusing on immigration and crime, actually spreads out across all other agencies, including agencies where it really is inappropriate in terms of health and social support, welfare support, and how its tentacles really have become wider and wider. So Joan, I hope that you'll be able to give us some of that information. And again, thank you very much for being willing to contribute today.
Okay, thank you so much for having me. And the same case is a case of, it has a lot of aspect to it, but today I will just stick to a few, because what has happened to Asim shows a long history of failings by the authorities and how it has led to the threat of deportation now. In speaking to you about Asim case, there are details I cannot go into because they are relevant to the challenge to his deportation. And I don't want to say anything to undermine that. There are lots of details of Asim case that need to come out and will come out, but I cannot go into them right now. But Asim faces deportation because he was convicted of a crime in relation to a theft of mobile phone. And Asim pleaded not guilty. He said he was there, but not involved. A witness in particular is the friend of the victim supported this claim. We concerned about the issue of joint enterprise, and we are concerned that there were no account nor regards given in the trial of Asim autism and other disabilities. Because he was sentenced for 5 years, the presumption is to deport him. The first decision to deport was upheld, and the then judge claimed Asim was not culturally orientated to this country. Also, he lived here all throughout his formative years and only lived in Jamaica until the age of 4. He cannot go back, and literally picked up where he left off, as the judge alluded. The case is going back for a fresh decision in the first higher tribunal, which was why, but we will ask this question, why was Asim in a situation where he could be convicted of a crime like this? Well, I would say because of social service failings. He was illegally and wrongfully taken into care at age 16 by social service. He had never been in trouble before this move, and it was only whilst he was in the care of social service this happened. In care, both his emotional and physical need was neglected. Social service again and again proven itself to be a poor, segregated parent. Oh, this is hard. I always say that social service is a gateway into this terrible lifestyle if they haven't got people to direct them. And why was Asim taken into care? Because of educational and social service failing. Asim has complex needs, autism, learning disabilities. He has a emotional and age and intelligence of a child. And he was challenging, at that age he was 16, and social service stepped in, they agreed, and they didn't, without probing into his complexities. Yet, at the same time, I have been crying out for help for Asim throughout his schooling, but he was never statemented. He never get the support he needed. If he got into trouble at school or because of his autistic behavior, he was disciplined, and he was seen as defiant and disrupted Black boy. They never give him the care he needed. He was assessed by the school without me knowing, and it was worded and documented that they believe he's got autistic, but nothing was done. He was seen as defiant, as I said, but he never got the help he needed. What happened to Asim? happen to so many children who are autistic and have other learning disabilities, and to Black children, boys in particular. He was failed by the authorities in terms of the extra support he needed. His needs were seen as a disciplinary problem, and then by the justice system and criminalized in ending up in prison. In prison, he was abused, discriminated against, called derogatory names, punished, isolated, ganged upon, and deprived of food and medical care. Oh God. Asim in prison because of his abuse in prison because of his artistic behavior. His whole life is like a conveyor belt, and it may very well land him in Jamaica. Many like Asim face the double punishment of prison and deportation. Asim should not be under the sentence of deportation and should not be deported. He left Jamaica when he was 4 years old. He has no family, no friends, no healthcare system to provide the care he needs. He didn't get the care in a rich and enlightened country like the UK. How is he going to get it in Jamaica, where he will be seen and threatened as a foreigner, and who has no right, and in a country that struggles to deal with the reality of disability? Legal case is currently underway, challenging deportation. No hearing date, probably not for several months, probably. We are in the process of appealing the criminal conviction. Right now, the priority is Asim health and to lift the threat of deportation from off his head. It's destroying him and the family, and he's struggling to cope with this uncertainty. For him, it's a torture, like being on death row, honestly, not knowing why or when. Asim developed this heart problem whilst he was in prison because he was given large doses of antipsychotic medication. And he's not psychotic, he's autistic. And it led me to say, I have never liked to say this, but I have to say it. Racism is historical and it is rooted in the past, but you constantly see it operating on a daily basis. It's sometimes, I would say, it's like a bullet everywhere and in every sphere of life, like a bad nightmare that I cannot escape sometimes. There are different traumas, different heartaches that people of color have to live through. It is a perpetual trauma that we, and particularly Black men and youth, have to endure. This country has a difficult conversation and decision to make, and today's is about race. Take, for instance, Asim case, and as I have already said, there are many, many Asims out there that have been failed by the system, its hostile policy and biased officers. When you think about the totality of these circumstances, you realize that we have made progress in some area, but we still have not reached the mountaintop where Black parents and Black can say that they are not judged by the color of our skin, but by the context of their character. We are far from it. I am not so concerned about people calling me Black, but I am concerned about the level of systematic oppression people of color are facing today. There are many, but I will mention a few. An hostile immigration system, broken criminal justice system, and social service, the school, For these have impacted me at the core. Many people, unfortunately, are punished because of the postcode they are born in and grow up under, and the color of their skin. All of these unnecessary pressures, they bear upon you, driving you into the ground, destroying your physical, mentally, and socially. Me and my son and my family, we just want to pass some time and breathe. Some ill-informed people will say we should leave their country. We are not illegal. We didn't come here. We were first taken and then invited to come here to contribute, which I did. My grandfather came to this country in the 25th of July 1960, and he worked. My grandmother went back to Jamaica and she could come back. She died there because of the hostile environment. I think some people, including the government, have lost the value of what a life is, especially when we can inflict pain and suffering on others with impunity. One cannot fight for his life if we can barely survive, and that is what the hostile environment has created. It creates a lot of consequences for us as individuals and a people. The government needs to look into their policy because everyone should be treated with basic dignity. We were told whilst growing up that Britain was our motherland, and we willingly brought into it, embraced it. But now we are severely punished and discriminated against for none other than the color of the skin. I have felt it, I have seen it, and I have lived it. I would be ignorant and blind to the fact if I said that race did not play a role in receiving negative treatment in school, in the social care system, and in the criminal justice system. It's not government that makes this country great, but the many millions of kind and generous people up and down the country who believe in value, fairness, and justice. Please support the campaign. It is on unprecedented level with over 357,000 signatures. Please support the fight for justice for the same and for all Black boys being criminalized for having a disability and just for being Black. It can and has been proven that Black men have been dealt with more rashly than their white counterparts. Let's make a difference for all neurodivergent people and Black who are disproportionately criminalized. We need a law around police investigation and accountability. We in the Black community have little faith in the police, and that needs to be changed. Thank you so much for listening to me. Thank you.
Joan, I'm sure I'm speaking for everybody in saying you should not be saying thank you to us, but we should be saying thank you to you for such an eloquent and emotional explanation of not just your own experience, but to lay bare what is the most heartbreaking consequences of structural racism that run through our society. And there's very little that we can say today that is going to address the magnitude of what you've experienced as a mother and as a member of this society. We take on board what you say about supporting the campaign, and I'm going to repeat that at the end, but it shows the magnitude of what we face. And I can only say, I'm so grateful that you were willing to share those experiences and your thoughts with us today. Thank you very much. We are now going to hear from Maria Broll, who is a Senior Advocacy Coordinator at Detention Action. Detention Action is a charity that works in particular in the field of immigration detention, and it has been at the forefront of campaigning against forced deportations, in particular the spate of charter flights and the flights to Jamaica. And so we're again very fortunate to have expertise really again from the front line in providing advocacy and casework advice and assistance for people who are facing what, as Joan has so movingly, graphically explained, is the enormity and magnitude of being subject to multiple ways in which the state has seeking to deny your rights and to subject you to multiple different forms of abusive treatment, ultimately culminating in proposed deportation proceedings. So we're very lucky again to have Maria to give us her insights of working on the front line in organising campaigns against this kind of state activity.
Thank you. Thank you for inviting us to this discussion. And I think I'll try to keep it brief because I think everybody has really spoken extensively on exactly what is problematic about these kind of mechanisms, and especially Operation Nexus. I think that's been highlighted by everyone who's already spoken, is that it is an overt mechanism that is overtly kind of systemically racist and overtly targets the Black and Brown community, the young community, through the criminal justice system and through policing. And within Detention Action, that's what we see is a cross-section of these different mechanisms, and Operation Nexus being one of them that we speak to kind of with many people who access our advocacy and casework services, as well as our campaign services, our campaigns networks, talk about Operation Nexus, but also some of the other areas of kind of racial profiling that have been mentioned earlier around joint enterprise, also talking about still seeing people who are under IPP sentences, although abolished. And these spaces are, and these mechanisms are used specifically within the, Black and Brown minority and ethnic communities, and facilitate the deportation and removal. And this is the cross-section of people we see and that we support who are under deportation orders. And I think what Joan was especially speaking on as well, and so powerfully and so importantly, was highlighting the impact on the young people and the people within kind of the ethnic communities who were targeted through this. And not only through the criminal justice system, but also other areas of statutory services who work together to gather this intelligence, to facilitate deportations, to facilitate removal, as Greg said, gathering intelligence and evidence that has no basis or holds no weight or within normal realms of legal measures would be kind of, would hold any relevance or importance to it, and that these are applied to people kind of who are detained and are under deportation order. And it shows a real level of statutory services working in partnership to kind of have this culture of a hostile environment practice across services. Like Joan said, social services implementing practices to facilitate deportation, to provide information for judging and talking about characters of young people, rather than looking to assess and support and provide protection for the young people that they should be within the social care service. Or there's been instances talked about within Families for Justice and other spaces within detention action where services such as the probation services aren't looking at rehabilitation, but instead are facilitating discussions across partnership organisations, whether they're multi-agency spaces where you have social care professionals, healthcare professionals, criminal justice professionals, gathering intelligence to facilitate deportation and removal, rather than gathering, you know, statutory services and partnership agencies to support and protect the people that they're there for, rather than providing risk management or support or safeguarding children or safeguarding adults. There have been, you know, instances where people have felt over-assessed or intrusive social care measures from social services. Families for Justice is a group of a collective, a network of campaigners, of family members. And within this collective, we have some really powerful women, Joan included, who's one of the members of that, you know, who are nurses, social workers, proprietors of businesses, frontline support workers within care, within children's services, within nurseries, and who themselves have been the families of people under deportation orders. And not only do these kind of practices of Operation Nexus or joint enterprise or the hostile environment kind of culture across services target the individuals, but what we've also seen is they target the families as well. And they target the families through kind of abuse of power in some instances, where referrals are triggered through from probation to social services. And when questioned by individuals, when questioned by the family members, the mothers, the partners, the siblings, of why this social service referral was triggered, there was no actual clear line of public protection or protection of the young person in question, or protection of the family member, or for the purpose of rehabilitation of the person in question. Sometimes these referrals are triggered for further monitoring, further assessment to continue to facilitate deportation and removals. So in a way, we see a lot of these organisations working together for immigration purposes, but we question whether these organisations are also working, or when we do require support in healthcare or in social care, or for rehabilitation, or for protection of the children, or for the adults, these mechanisms aren't being used in these spaces. And where Families for Justice, as mentioned, is a collective of individuals who have a wealth and a spread of experience within the social care system, they're able to advocate for themselves and for their families, and question why they're being over-monitored, over-assessed, intrusive risk assessments and monitoring happening to them. But as Joan said, ASEEM is one example of where that's happening continually, and where people might not have the same area of knowledge, because it's not, they don't sit within the social care space or have the advocacy support around them. And it also highlights the cross-section of legal spaces that families have to go through: family law, criminal law, probation law, immigration law, to ensure they're advocating for their rights in all areas, and hold statutory services responsible for instances where there is questionable social care referrals or mismanagement, and facilitating over-monitoring. And I think it's important to have these campaign groups, and to ensure that we are providing and holding accountable services where people feel they might not be able to advocate for their rights, or are not being given the information on their rights. and access to justice, I suppose, in all those areas of laws where Operation Nexus as a police system, or where the hostile environment through, you know, healthcare systems or social care systems would try to implement immigration law. Yeah, so I think that's where we try to support and provide advice and advocacy, but it does definitely show the kind of cross-section of statutory services that that continue to facilitate deportation and removal, and Operation Nexus is definitely one of those areas.
Maria, thank you very much. And again, we can only pay tribute to all the work that you and others at Detention Action have been doing in order to provide some accountability and to seek to prevent this juggernaut of a policy that is, as Joan has explained to us, destroying so many people's lives. Thank you very much. And certainly people have been asking in the chat about how they can sign the petition in support of your son, Joan, and we've put that in the chat. And you're aware from what Maria said about the Families for Justice campaign, and I'm sure it's being run on an absolute shoestring. So if we can also look to ways in which we can make a contribution to that, I don't know if that's possible, we can put that in the chat, and we can certainly follow up with that later so that we can try to make your work as effective as it can be. So we do have quite a number of questions. I'll see if I can kind of group them together. There were a number of questions that are really focusing on what Greg said relating to the process and the evidence that's used. So Alex Taylor Kamara is a barrister at Garden Court Chambers and had raised a couple of questions about that. And he asked about whether or not they're using Met Gang Matrix. I think that Dr. Palmer explained that they do use that as part of the intelligence, that is used. And the other question that Alex asked was whether or not there's intelligence used from abroad, not just from within the United Kingdom. So I don't know if you, and just a related question in terms of documents and material, there was a question about disclosure obligations and whether or not the tribunals are holding the police to account and the Home Office in providing documentation. So Greg, I don't know if you want to, maybe Alpa have a follow up on that.
In terms of evidence from overseas, I have seen that, and there's a real issue with evidence from overseas, and that it's often really hard to figure out what it means, because if you see a PNC printout from the UK, I mean, we're all familiar with those generally, we know what they mean, but if you, for example, it's not really clear, particularly in different countries, they have quite different legal systems, what the documents necessarily mean. That does happen, but I don't think it's something that particularly happens with Operation Nexus. In terms of disclosure, as I said, it's basically should not be disclosed. There's no procedure for a disclosure application, though of course you can make one. The case law says that the police producing the Nexus documents shouldn't cherry pick from evidence to just show information that suggests a person did commit a crime. But if they don't do that, you've absolutely no way of knowing. And there's no real way of the tribunal policing that. So I think the best you can probably do in those circumstances would probably be to make a Freedom of Information Act request, or to ask the tribunal for a direction for specific disclosure. But when, as Steph was saying earlier, what's really important here is getting a steer from the criminal lawyers as to what it is you should be looking for. Because when you're trying to effectively re-argue cases without all the evidence, it's very hard to know what's missing from the picture that you've got from the police so that you can ask for it.
Yeah. I think on that, Nigel Leskin did explain that it's perhaps easier to obtain the material than we thought. It's not like now having to although it could be going back for some time, that it is on a computer system, so it should be easy for defence solicitors to pass on the information to the immigration lawyers. And I know that's going to be finding the time even to do that, but I think that does make sharing of information, at least logistically, easier. There was a question following on from that, which was a recognition that, or an understanding that the Home Office may behave in this discriminatory and racist way. But the question that's being asked is, what about immigration judges? Why are they prepared to tolerate this sort of material being utilised in legal proceedings and to act upon it?
Is that for me? Is it?
I think so.
I mean, to be fair to the immigration judges, I do think, as I said, that I think they're just quite impressed by policemen turning up in uniform with, because it's not like in the mags where you regularly see police officers fall apart under cross-examination, and in the Crown Court there isn't the same. They're just not as used to police officers, and I think there's an element of respect there that isn't necessarily very helpful to somebody who's facing these kinds of allegations. But I mean, there are obviously biases in tribunal judges, like there are anywhere. But in general, I think certainly the level of the first tier tribunal, they're just following what the law is, and the law is the problem. I mean, the problem is the tribunal is allowed to admit evidence that you'd never dare darken the door of a Crown Court with this kind of evidence, and it's having an impact in many cases that's actually more serious than the impact that would be in the criminal context. And that's why I think we need to be thinking about, bringing Article 6 back into the equation in the common law.
I think just in terms of dealing with this sort of case, the idea of asking for further disclosure and those kinds of approaches, which you would do in ordinary civil or criminal proceedings, you don't really want to go down that route, because all that's going to do is to generate more material potentially. And the only strategy that I've ever adopted in these sorts of cases is to try to get the whole thing not to be looked at. That's difficult because of the reason that Greg has said, but that has happened in a number of cases. So, for example, I had a case, the case of the person who was they relied on the conviction when he was 15. He actually got deported to Jamaica, so he had an out-of-country appeal, and they wanted to rely on similar sorts of material that I showed you earlier, and he was supposed to be going to be dealing with that from Jamaica. And on top of that, he also had significant mental health difficulties. And so we were able to use fair trial arguments to be able to say there's simply no fair way in which you could begin to test or cross-examine or us to respond to this material because of the disadvantages. And obviously there was an acute disadvantage because the client had already been, as it turned out, unlawfully deported to Jamaica. But we were able to use that. And some of those factors would be, I mean, it simply is impossible in lots of cases to even begin to address it. And many clients do have additional difficulties. They're vulnerable witnesses, and you have to try to use what you can from the protections that there are. And it's quite extensive for vulnerable witnesses to say, look, it simply is not possible to have a fair hearing of where you're using this kind of volume and nature of evidence, and that has worked, but it's very much in an individual basis. So I think those are all the questions relating to the kind of process. We have some other questions, if I just give me one moment.
Could I just say, while you're yes, on the back of that, so with information about previous convictions, the police have quite an intricate system of exchanging information now through ACRO, so the Criminal Records Office. And I even saw a situation where the police here in the UK are going over to Jamaica, for example, to improve their records so that it's easier to access that information from the UK. And these kind of agreements are really being put in place often for evidence purposes. So I think that is happening more and more.
Yeah, well, that does follow on with another question, which was what is the position of countries like Jamaica, and are they opposing return of people who are long-term residents, children of British citizens, etc.? What's the position of the Jamaican authorities?
I mean, I don't know much about the perspective of authorities, but from the records officers there, I saw that they were quite glad actually to have the help and the assistance. And of course, it's a problematic colonial kind of relationship that's being reignited, I suppose, and that's problematic in and of itself. But I also think it's important to point out that sometimes people who are going back there were quite stigmatized too. And as Joan said as well, there isn't the access to help and authorities. Things like mental health services aren't there necessarily. So I think that the authorities are seeing it as an additional problem that's being created by sending people there without the resources to deal with the issues.
Yeah. I don't know if anyone else wants to contribute, but I can certainly say that from the particular case that I had, because he was deported, we were able to see what happens when somebody returns. Most of the time you're speculating about, will there be support? Will you get access to medical care? And the Home Office can rely upon the fact that it's speculation, and they can drum up a distant relative or the possibility that there is a psychiatrist or a psychiatric hospital in Kingston, even if there isn't one in the area where your client would end up. And what actually happened to this man was that his return was facilitated by the UK authorities to a kind of hostel, which was a sort of shelter, that a very old dilapidated shelter that the UK government had funded a sort of separate part of it, which was much more modern and newer. And the returnees were sent back to there, and they were taken in a taxi organised by the Home Office to this hostel accommodation. And the idea was that you would remain within this kind of reasonable accommodation, hostel accommodation, for a short period of time until you could integrate, because it was based on the basis that you could. But because this man had extreme mental health vulnerability, he was moved quickly out of that facility into the other facility, which is parallel to it, which was utterly dilapidated, which was full of rats, cockroaches, you name it. It was a degrading environment. His mental health seriously deteriorated. He actually spent most of the time sleeping outside because it was dormitory accommodation, and he was absolutely petrified. He was subject to 2 knife attacks, and he got no medical care save for the fact that a doctor who had seen him in the detention centre in the UK and had said he wasn't fit to be removed, but he'd nevertheless been removed. We had asked him, he intervened to phone up to a psychiatrist in the hospital in Kingston and got him some medication, because he was sent back with literally nothing. He had no medication at all. No notes were provided to assist with any kind of continuity in his medical care. And in the first tier tribunal, we won his case. They concluded that his treatment was inhuman and degrading. So a breach of one of the most serious breaches of the Human Rights Convention that you could have. And ultimately, we're able to return this man, but it took 6 years. In the meantime, he was in the most appalling conditions. So on the one hand, there is close cooperation between the Jamaican and the UK authorities, because the UK is providing these facilities in order to facilitate removals. But they do so, as this case showed, knowing ultimately that for the vast majority of people, what they say about why they can't be deported, i.e. they won't have any family or support, they won't have access to medical care and treatment, and they're likely to find themselves destitute and at the risk of violence and other kinds of abuse, is actually the case. And that's what this case showed. I think that Jamaica has a schizophrenic position. It's facilitating, but obviously it was very important, along with other Commonwealth countries, in voicing and ultimately triggering the change in the Windrush, or the recognition that for the Windrush cases, that had been a complete scandal and abuse. So they are willing, and they did use their political power there. And maybe that's somewhere where we need to be focusing attention now for those governments to do what they did, having seen it exposed the appalling treatment of what's called Windrush generation. Obviously, it's not limited to Windrush generation people. It's their children and grandchildren as well, as we're seeing it. So I think that maybe there's merit in thinking about how pressure could be brought to bear for the Jamaican authorities to actually stand up and say, we cannot and we do not want to have to deal with the return of this category of person who's integrated and should be allowed to remain in the UK with their families. So that was that question. I don't know if, Maria, you know of any kind of response that there's been from the Jamaican authorities in light of the charter flights and the publicity around them.
No, I think it's quite an elusive kind of just like agreement that's there, that we all try to get a better grasp of and understanding of, and the more we try to find out across different spaces and organizations, it's still not very clear what the agreements are in terms of removals and charters. And I think I think it's not something that the government are willing to share, or the Home Office are willing to share what agreements are made with each individual state or government, and especially now as well, thinking about the exit of EU and Brexit and the bilateral discussions they're now trying to have with European countries and trying to replace Dublin Third regulation and the removal of people, administrative removal. So I mean, we're not privy to those discussions the same way that we're all trying to theorize what the links are. Like Alpa said, you know, there's also the colonial links within the Caribbean countries and other Commonwealth countries where removals are happening, and you can even look into, I suppose, the funding around kind of other areas where they might fund into the criminal justice system within Jamaica, and that could arguably also be a way that these charters and other charters are facilitated by the government. But I don't think we're any clearer on that as other organisations or other firms are really.
Thank you very much. I think the other focus of a number of questions is basically asking again, how is this being allowed to occur, and is there a way of challenging it? And I think that Greg can probably will follow up on this, but that he showed you the case law that has effectively sanctioned this source of evidence, and there was one strategic challenge, which also Maria talked about, that the Air Centre brought about the questioning of EU citizens, and each of them have failed, and we're really facing with dealing with cases on an individual basis, case by case basis at the moment. I don't know if, Greg, if there's anything else that you think that there is by way of strategic challenge to this.
I'm not aware of anything that's up and running. As I suppose I kind of was trying to suggest in the talk, I do think that there is room there, and I think particularly at Strasbourg level, I think there's now room to talk about Article 6 protections in the deportation context. And it may be that taking a case that far is the next step. But I think you know, like I said, a lot of these case fairness provisions, I think common law fairness requirements, I think, are being talked about more in the higher courts now than they have been for some time, and it may be that that's another angle that can be taken as well. But I do think these issues are ripe to be revisited, but at the moment the way the law is pretty dreadful.
I mean, it seems to me, and this probably reflects what is the vast majority of the contributions in the chat, is what we need is the ability of Joan and others who can speak so powerfully and eloquently about what this system does to them and to their families, to those who make these decisions, so they understand the consequences of it. And clearly, ultimately, although it took a decade for the exposure of the unlawful treatment of British citizens who were from the Windrush generation, it was in part through parliamentary investigations that really blew that open and exposed it. And so I think that is the route also to be looking at, is that it does need to have an investigation by the Joint Human Rights Committee or the Home Affairs Select Committee to look at what is happening with these wider deportation practices and powers, and that might be another route through, and to give a platform to speak directly to those who are making these decisions and implementing this policy. I can't think of any better advocate for change than Joan. And I don't know if you're able to read the chat, Joan, but we can send it to you separately, because everybody is there commenting on just how incisive and powerful your contribution was. And I'm sure that's going to stay with all of us, and where we can, whether it's in our legal practice or in directly supporting your son's case and the wider campaign. I hope that everybody who's participated in this seminar will follow up, at least by supporting those two things, signing the petition and looking at ways of supporting the family's justice campaign. We've obviously heard a lot from the immigration perspective. We do have the benefit, if he's able to do so, of Keir Monteith QC, who's a criminal practitioner. And we're keen, if he's able to get his contribution from a criminal law perspective. And maybe just before we conclude, we can hear from him, if that's possible. I can see that he's there, but I don't know if he heard that. Well, I'm really sorry that that doesn't look like that's going to be possible. This series of seminars is ongoing, and there is a planned series of further seminars that are going to focus on the interrelationship between immigration and criminal justice. This one was specifically focusing on structural racism and the interrelationship between stereotyping and profiles, but some of the others are more focused on providing practical advice to and assistance to criminal lawyers faced with clients who have immigration problems and other interfaces, whether that's in the context of trafficking victims and prosecutions of that particular cohort of person. And I'm sure that we'll be able to pass on those details, and we'd hope that you would join again so that we can continue with this conversation and exchange of experience across both disciplines, immigration and crime. But always remember that ultimately what we're faced with here is the most serious issue of our time. As Joan said, both criminal justice and immigration law have to be looked through the prism of race and structural racism in the United Kingdom, as Joan again said, both historic and contemporary. And it's given that that is the case, being lawyers who just do with individual cases, well, that's critically important at this time and at this juncture, that's not enough. And I hope we will all join forces to assist with those who are seeking to challenge this most pernicious of state practices. I don't think that there's any other questions that I've missed in the chat, and so we're a little bit over time, and I'm going to draw the panel to a conclusion, and thank you for participating.